प्रोबेशन
इनके खिलाफ क्या मैं बता रहा हूँ,
हाँ
इन्होंने ऑर्डर शीट में लिखा कि जजमेंट प्रोनाउंस,
हाँ
जजमेंट प्रोनाउंस नहीं किया। ये कंप्लेंट की किसी
हाँ
पक्षकार ने कि जजमेंट नहीं मिला, तो रीजन एक्सप्लेनेशन कॉल किया। इनका एक्सप्लेनेशन ये था कि इमीडिएटली विंटर वेकेशन लग गया था, मैं छुट्टी में चली गई।
अगर आप प्रोबेशन डिसकंटिन्यू कर रहे हो या
हाँ।
नॉट एक्सटेंडिंग दी और यू दी प्रोबेशन पीरियड,
हम्म।
then whether it will amount to be dismissal, termination or what.
Now, at least 10 other
So you
candidates
have also called the report from vigilance
in that case.
in the present
नहीं,
case.
इसमें तो कंप्लेंट्स आई, कोई रिपोर्ट नहीं
तो
बुलवाई।
विजिलेंस
नहीं, वो राजस्थान में विजिलेंस की रिपोर्ट है,
नहीं नहीं
इनके खिलाफ
हमारे
कोई
यहाँ
करप्शन का चार्ज नहीं है।
no correction नहीं है, but on the basis of the complaint,
हाँ।
if suppose if any complaint is made against anybody and without examining the genuineness, भाई देखिए the profession
इनके खिलाफ क्या मैं बता रहा हूँ,
हाँ
इन्होंने ऑर्डर शीट में लिखा कि जजमेंट प्रोनाउंस,
हाँ
जजमेंट प्रोनाउंस नहीं किया। एक्सप्लेनेशन कॉल किया गया जब ये बात, ये कंप्लेंट की किसी पक्षकार ने कि जजमेंट नहीं मिला, तो रीजन एक्सप्लेनेशन कॉल किया। इनका एक्सप्लेनेशन ये था कि इमीडिएटली विंटर वेकेशन लग गया था, मैं छुट्टी में चली गई। विंटर वेकेशन के आके 10 दिन बाद भी वो जजमेंट फाइल में नहीं है। इसमें क्या रिपोर्ट आई? एडीपीओ ने कंप्लेंट किया कि कंप्रोमाइज के बेसिस पर केस खत्म हुआ, इन्होंने कंप्रोमाइज ना लिख के मेरे हाजिरी में प्रोसिक्यूशन एविडेंस नहीं देना चाहता है। तो उसका एक्सप्लेनेशन इनका यह है कि वो एडीपीओ को कुछ दिक्कत हो जाएगी, इसलिए मैंने ऐसा लिख दिया।
where that all the documents is in the record.
सब है।
Yes.
Even otherwise, it may not be true that just because there existed on record some allegation of extraneous consideration that the High Court was precluded from terminating the service of Respondent 1 in simpliciter manner while he was in probation. The unsatisfactory performance of a probationer and resultant suspension of service at the end of probation period may not necessarily be impacted by the fact that meanwhile there were some complaints attributing specific misconduct, malfeasance, misbehavior to the probationer. If the genesis of the order of termination of service lies in a specific act of misconduct, regardless of overall satisfactory performance during the probation, the court will be well within its reach to unmask the hidden cause and hold that the simpliciter order of termination, in fact, intends to punish the probationer without establishing the charges by way of an inquiry. However, when the employer does not pick up a specific instance and forms his opinion on the basis of overall performance during the period of probation, the theory of action being punitive in nature will not be attracted. Onus would thus lie in the probationer to prove that the action taken against him was of punitive characteristic. पूरी रिट पिटीशन में एक भी सिर्फ अवरमेंट है कि मैंने दो जजेस के खिलाफ मैंने कंप्लेंट की थी इसलिए लिया। वो दोनों कंप्लेंट जो हाई कोर्ट ने उसको क्लोज कर दिया कि पहले कैप्टन अवेंस रखा, उसको क्लोज कर दिया।
कब क्लोज किया?
बहुत पहले
है रिकॉर्ड।
हाँ, उसमें कोई एक्शन नहीं लिया। इन्होंने अवरमेंट किया कि मैंने दो के खिलाफ कंप्लेंट किया और वो हो गया।
वेयर दैट रिकॉर्ड की कब क्लोज कर दी हाई कोर्ट ने?
ये
बताइए।
पेज नंबर 401।
कब क्लोज किया आपने?
411 411
पेज नंबर क्लोज्ड।
इसको मैं पढ़ देता हूँ।
हाँ पढ़िए।
Resolution. Considered the complaint dated 6/4/2016 and 25/4/16 made by Kumari Akansha Bhardwaj against Shri Anand Prakash Warrior, the then CGM Ambikapur and Shri N.K. Chandravanshi, District Judge Ambikapur. The complaint was labeled charges of sexual harassment against Shri Anand Prakash, harassment against Shri N.K. Chandravanshi, but has otherwise complained about him.
वो आप हमको फ्लैग करके दे दीजिएगा, हम पढ़ लेंगे दोनों रिपोर्ट। फ्लैग करवा दीजिए। वो
रिपोर्ट फाइल नहीं हुई है, मैं आपको दे दूंगा।
अब वो स्टील लिफाफे में दे दीजिए।
दोनों रिपोर्ट दे दूंगा। वो मैंने वो मीटिंग का लगाया है पेज नंबर 413 पर। कंसिडरेशन ऑन प्रिलिमिनरी इंक्वायरी रिपोर्ट डेटेड 26/9/16 सबमिटेड बाय रजिस्ट्रार विजिलेंस हाई कोर्ट 26/7/16 passed by the standing committee in the matter of complaint dated 25/4/16 by Kumari Akansha Bhardwaj, the then civil judge class 2 Ambikapur against the N.K. Chandravanshi district and session judge. Resolution resolved to accept the report of the registrar vigilance and to drop the matter.
So I want to see the report. Please give it in an envelope to me. I will go through it. Yes.
तो ओनस इनके ऊपर था कि मैंने इनके खिलाफ कंप्लेंट की थी इसलिए एक्शन लिया। Simply making an averment and filing the complaint, she had not disclosed what has happened to those complaints.
Yes, that's why.
Yes. He had not disclosed. कि मैंने कंप्लेंट किया था इसलिए मेरे को विक्टिम किया, क्या वो नहीं बताया. तो she has to prove that this was the basis. वो पूरी पिटीशन में मिसिंग है. Conclusion है, since respondent 1 has failed to establish that the High Court intended or has actually punished him for any defined misconduct, it stands crystallized that the object of the High Court on the administrative side was to verify the suitability and not inquire into the allegation against the first respondent. Independently also, we do not find that the foundation was the allegation, but it was based upon a holistic assessment of the respondent's service record. Even taking an effect-based approach, we do not feel that the order of non-confirmation or preceding circumstances would prejudice the respondent meriting a higher procedure required. तो इनका तो केस इनसे अच्छा था, तो उसमें सुप्रीम कोर्ट ने बोला कि मेरली गुड है तो नहीं होगा, ओवरऑल परफॉर्मेंस उसमें वेरीफाई करना होगा. इसमें भी एक बार एक्सटेंशन मिला था, इनके केस में भी एक बार इनको एक्सटेंशन मिला, और उस एक्सटेंशन में कुछ नहीं हुआ. इन्होंने कुछ अपने एसीआर्स लगाए हैं, लेकिन वो एसीआर्स हैं 15-16 के. जो पीरियड था इनका कंफर्मेशन का 14-15 था, जो टेकन इनटू कंसिडरेशन, क्योंकि 15-16 का एसीआर तो कम्युनिकेट किसी को नहीं. 14-15 का अगर एसीआर ही मैं लाया हूं, अगर उसको देखेंगे शी वॉज बिलो एवरेज, वो भी दे शी वॉज बिलो. यस, वो भी दे शी वॉज बिलो. Yes. There is a basic difference between termination and
yes, that is the issue which.
On the last date of hearing, I had referred that Mahanadi Court will judgment,
yes,
in which all the previous judgment has been taken into consideration, and thereafter the court came to the conclusion that this is the difference, that in termination, the candidate is free to get an opportunity of employment in some other sources or even in the same source.
Yes.
But so far as dismissal is concerned, since it is an stigmatic, the candidate is precluded to get an opportunity.
And what was the power given to the standing committee?
The power is given to the standing committee is to give a decision other than dismissal. Termination word is there, other than dismissal. So the standing committee has not resolved that her services should be dismissed. The standing committee had resolved simply to terminate his services. So standing committee was having the judgment.
So you want to say that the word used in the rules 4C of the rules, the word is to be understood.
Word is used other than dismissal.
Other than dismissal. And other than dismissal, whether when he was discontinued or probationary period, whether it has can you give one law on this issue? Whether even if he has been probationer has been not extended, probation period has not been extended, it will not amount to termination.
ये राजस्थान का जजमेंट यही है.
He doesn't deal with the particular this question which I want to put you, Bharat, whether the probation, if not extended, will amount to dismissal or termination.
वो तो 311 के स्कोप से बाहर हो गया ना.
Where
311 का स्कोप इसमें रेफर किया है राजस्थान वाले जजमेंट.
Yes, बताइए वो बीच पैराग्राफ.
Paragraph 14.
Yes.
The present case is one where the first respondent was a probationer and not a substantive appointee, hence not strictly covered within the umbrella of Article 311. The purpose of such probation has been noted in Qazia Muhammad Muzammil versus State of Karnataka. The purpose of any probation is to ensure that before the employee attains the status of a
No, my question is different. अगर आप probation discontinue कर रहे हो या not extending the or you the probation period, then whether it will amount to be dismissal, termination or what?
Now thereafter we have to see what the order was passed. The impugned order simply says termination. It does not refer the word dismissal.
No,
it does not refer the word.
That's why I want to know.
It would not be.
It's Bharat, that's why I want to know if the probation period is not extended, what will be treated? Whether it will be dismissal, termination or what?
It would be termination, simply stated termination, because
where is the law?
Because the rule, what the rule says,
yes,
that the probation appointed for a period of 2 years on probation.
No.
The rule.
Which Bharat, the probation period is not extended.
Let me say.
Yes.
For 2 years. The rule further says that after completion of 2 years, the candidate would not be automatically confirmed. The rule further says that the probation can be extended.
Yes.
And rule further says that until and unless that probation, a order of confirmation is not passed, it would be deemed to be on probation. Now, in this case, what has happened? The probation was extended for one time.
Yes.
and thereafter it was resolved not to continue with the probation.
Yes.
So the result would be,
So whether it has
the end
been,
result would
no,
be,
no, Mr. Bharat, whether the period has been extended for 1 year or for which period?
for a period of 1 year.
So whether whether in a period of 1 year, whether the subsequent order not to continue has been passed within 1 year or after 1 year?
After
Completion of 1 year.
yes.
When the order was passed on,
The order was passed on, the first order was passed. तो फाइल बन गई।
हाँ, ये है ना, हमने आपको दिया रिकॉर्ड, हमको वापस दे दीजिएगा।
नहीं, मैंने आपको वापस कर
वो नहीं वापस, ये हमारे पास अभी ये नीचे वाला रिकॉर्ड आपके पास
ये
है।
पहला ऑर्डर 18 मार्च 2016 को ऑर्डर हुआ।
हाँ,
ये एक्सटेंशन का है।
हाँ,
और उसके बाद जो है, हाँ, और जो दूसरा जो ऑर्डर हुआ,
हाँ,
इसमें कोई टाइम स्पेसिफाई नहीं है। द पीरियड ऑफ प्रोबेशन ऑफ द फॉलोइंग प्रोबेशनरी सिविल जज ऑफ लोअर जुडिशियल सर्विसेज एज स्पेसिफाइड इन कॉलम 2 ऑफ द टेबल बिलो इज हियर बाय एक्सटेंडेड। बस वो 10 लोगों का दिखा है कि इनका एक्सटेंड किया गया। अब जो इम्प्यून्ड ऑर्डर है,
हाँ,
वो है एनेक्चर P1, 9 of February 2017, एनेक्चर P1। और उस दिन सबका कंसीडर किया, पूरे 10 ऑफिसर का जिनका एक्सटेंड हुआ था। 9 को का ओवरऑल परफॉर्मेंस ठीक था और कंप्लेंट्स नहीं है। डिस्ट्रिक्ट जज के जो इनकी रिपोर्टिंग अथॉरिटी है उसके कमेंट्स एडवर्स नहीं है।
हमको एक चीज थोड़ा और बताइए मिस्टर भारत की प्रोबेशन पीरियड का इफेक्ट क्या आएगा, वेदर इट विल बी टर्मिनेशन और डिसमिसल, नॉन एक्सटेंशन ऑफ प्रोबेशन पीरियड।
नॉन एक्सटेंशन रूल में 3 चीजें हैं।
हाँ,
2 साल, जब तक एक्सटेंशन, और जब तक कंफर्मेशन नहीं होगा तब तक यू आर इन प्रोबेशन।
हाँ,
नाउ इन हर केस व्हाट हैज हैपेंड, इट वाज एक्सटेंडेड
हाँ,
and thereafter a decision was taken not to continue. So the two
what
orders,
will be its effect?
हाँ, वही
See,
बता रहा हूँ।
to fall within the ambit
मैं-
of
मैं
jurisdiction
बता-
of 4C.
वही बता रहा हूँ। नॉन कंटिन्यूएशन ऑफ द प्रोबेशन
Yes.
there would be 2 type of orders.
Hmm.
One dismissal and the other termination.
Hmm.
Dismissal must be based on some misconduct.
We don't know.
नहीं
See, your rule. See, please. That's why I want to specific your judgment on this point.
let me develop it.
Yes, yes.
Dismissal must be based on some misconduct.
Yes. How is it necessary?
Because in the dismissal, lordship, the candidate is precluded from getting employment in some other services. That is the basic difference between the dismissal and termination.
Please tell me the law. Please tell me as in law on this issue whether the term probation, if it is not this.
ये मानदी कोल फील्ड्स में
बताइए तो महानदी वाले को।
किताब निकाल दो ना। ये 2020 18 71 ये पहली बार कॉन्स्टिट्यूशनल बेंच ने आस्पेक्ट को कंसीडर किया था रामनाथ पिल्लई को।
And this Mahanadi has been referred from the against the gratuity rules.
हाँ, ये gratuity rules
Where the forfeiture of
recovery का है।
Forfeiture of amount of gratuity
Yes.
under the Mahanadi Coalfield. Where in which paragraph the Honorable Supreme Court has said, see, my question is different. My question is with regard to probation, if he is not continued. See, my question is different, on a different footing. My question is whether the probation is not extended, what will be the effect? It will amount to termination or dismissal.
वही मैं बोल रहा था। If the probation is not extended, then 2 types of orders can be passed.
Yes.
First is termination and second is dismissal. Termination is simpliciter termination means that the candidate is entitled to वो है क्या कॉपी है क्या माने दी termination simpliciter पिछली बार निकाले थे बाबू साहब, पिछली बार इसका प्रिंट solicitor would be that discontinuation. But if we pass an order of dismissal, then certainly 311 has to be complied with, as per the Ramnath Pillai's case. And even in this Rajasthan High Court's case also, if it is based on a misconduct, then 311 is
No,
accepted.
Mr. Bharat, my question is different.
I got
Yes.
my lord's question is that if the probation is not extended,
What
what
will-
would be its effect? Its effect is discontinuation of service. For
Discontinued-
discontinuation of
नहीं,
service,
see, discontinued service means whether it will be termination
No.
or
it,
please
it,
bring
it,
any.
it would be it would be based on the nature of order
See,
passed.
Mr. Bharat, you want to get rid of the rules of 4C. You want to say that the case of the petitioner does not fall within the ambit of Rule 4C of the standing committee rules. All right, but to get rid of the rules, you have to please bring the judgment whether the
मैं
probationer.
जजमेंट दे दूंगा, मैं
Yes.
जजमेंट ढूंढ लेता हूँ, दे देता हूँ.
Yes, yes.
But what I am submitting, non-continuation of a probation, the effect would be discontinuance of service. Now, discontinuance can be of two types: a simpliciter discontinuance and a discontinuance with an allegation. Now, in her case, it is a simpliciter dismissal. So, therefore, it would be a termination. If it is a discontinuation is on the basis of some allegation, then it would be a dismissal on the basis of misconduct.
आप हमको और सर्च करके बता दीजिए कि प्रोबेशन को अगर एक्सटेंशन नहीं किया तो इट विल
नहीं,
अमाउंट
कोई ऑर्डर तो पास करना पड़ेगा ना.
नहीं भाई, हम आपको प्रोबेशन पीरियड नहीं कर रहे हैं, खत्म बात.
हाँ.
So whether it will be treated as termination or dismissal, what is the basic? This is a basic issue which required to be answered by this court while dealing with the contention raised by the petitioner or by the High Court, that the rules of force. She is saying that Rule 4 is applicable, whereas you are saying that the case of the petitioner does not fall within the ambit of Rule 4. So to decide this particular question.
इसको जजमेंट में देख लेता हूँ.
Yes, please
देख
bring
लेता
that
हूँ.
judgment. That is the
non-continuation
that
of
issue will clear all the issues.
non-continuation of probation. What would it
Yes,
mean?
yes. This is the basic issue which is
According to me, non-continuation of probation would be
Pardon.
according to the order which has been passed. The order could be of two types: simpliciter or with an
See,
allegation.
this is a general phenomena, but
I will get it.
Since
I will
we
get
have to, you have to come over the rules, and she is saying that it is fall within the Rule 4. Therefore, termination, and as such, the standing committee has no role to play. This is the issue. This issue goes to the root cause of the case. If it answer is either in favor of the petitioner or the respondent, the whole exercise will be depend upon that finding only. Yes.
वो इशू पे नहीं, क्योंकि इसके पहले आपने क्वेश्चन किया था कि क्या वो किसी दूसरे जॉब के लिए एंटाइटल है या सेम सर्विस. So that has been answered in 2022 13 SCC page 1.
2022.
13
हाँ
SCC page 1
हाँ.
has been answered.
What it says?
What it says: termination of service of the probationer without inquiry does not deprive him of any right to post, and hence it is not a punishment. But if instead of terminating his service without inquiry, employer chooses to hold inquiry into the alleged misconduct on inefficiency, termination of service is punitive because it puts a stigma on his competence and he is entitled to protection under Article 311. और पहले वाले क्वेश्चन को आंसर किया है.
Yes.
और दूसरा वाला जो क्वेश्चन है कि अगर प्रोबेशन एक्सटेंड नहीं होगा तो क्या होगा, तो मैं देख लेता हूँ.
हाँ वो बता दीजिए. Yes, we'll continue. कब करेंगे?
अभी भी
Yes, भारत साहब, आप मैडम, आप बताइए कब करना है.
सर जल्दी.
हाँ, हम तो सुन ही रहे, लगातार सुन रहे हैं आप. जी सर.
अब बता दीजिए कोई तारीख.
यस,
नेक्स्ट वीक में कोई तारीख. मंडे ट्यूजडे छोड़ते.
वेडनेसडे लगा दो.
हाँ, 14th आएगा.
14 फरवरी. ऑलराइट. आर्गुमेंट
एक दो सबमिशन था सर ने जो पॉइंट रेज.
वो आपसे आपको देंगे अपॉर्चुनिटी.
मेरे बाद आपको मिलेगा.
आप विल गिव अपॉर्चुनिटी टू मेक विल गिव एम्पल अपॉर्चुनिटी टू मेक
मैं जो कर रहा हूँ उसको आप लिख लीजिए और उसके बाद फिर आप उसका
रिप्लाई दे दीजिएगा, कोई इशू नहीं. आर्गुमेंट कुड नॉट कंप्लीटेड, ऐसा लिखना. दिस कोर्ट पुट अ क्वेरी टू द लर्नेड काउंसिल फॉर द सीनियर काउंसिल ऑफ द हाई कोर्ट वेदर इफ द प्रोबेशन पीरियड इज नॉट एक्सटेंडेड will fall within the ambit of dismissal or termination. Let the senior council may make submission on this issue. List this case on 14th February, immediately in the list of fresh matter list. Fresh matter list में कर देते हैं, सुन लेंगे, उस दिन complete कर लेंगे.